very much, Jenny. Dear ladies and gentlemen, dear colleagues, first of all, let me start by thanking for your patience and attention. I'm perfectly aware that that is the last presentation during the two-day conference. That is why I've tried to prepare as short presentation as possible, and I even hope to be able to finish before I hear the bell, but let us see. So my presentation concerns the right to an effective remedy under the European Convention on Human Rights. It is established under Article 13, ECHR, which states that everyone whose rights and freedoms guaranteed in the Convention are violated shall have an effective remedy before a national authority, even though that the violation has been committed by persons acting in an official capacity. As you can see, not such an easy provision to understand. And the truth is that the right to an effective remedy has never entered a public debate the way that, for example, the right to the freedom of expression or the right to private and family life has. So these rights, they are inherent part of public debate nowadays, of many, public demonstrations or manifestations, and somehow their content is clear to everyone, even to laymen. That's not the case of the right to an effective remedy, which in that sense is not, let's say, celebrity among human rights. But nevertheless, it's one of the most important provisions in the entire European Convention on Human Rights. You may ask, how so? How is that possible? Well, I can answer by explaining it to you that the right to an effective remedy is part of a bigger mechanism, which is designed to secure the effectiveness, implementation, and enforceability of the European Convention on Human Rights. It consists of three main elements. These are the obligation of states parties to respect human rights, the obligation of states parties to provide effective domestic remedies, and their obligation to execute judgments of the European Court of Human Rights. As yesterday mentioned in the keynote address of Judge Peter Pezzolai, the European Court of Human Rights is a subsidiary forum for litigating human rights. And the principle of subsidiarity, it requires that the human rights and freedoms which are laid down in the European Convention shall be secured and applied first and foremost by the national authorities. This is also expressed in Article 35 of the European Convention, which sets out the so-called admissibility criteria for individual applications. It lays down, among others, the rule of exhaustion of domestic remedies. It means that individuals may resort to the European Court only after they have exhausted the entire domestic possibilities. And if Article 13 is not implemented properly, individuals will have to go straight to Strasbourg and will have no other choice than to refer to the European Court with their complaints, which normally could and should be addressed within their own national legal system. So taking into consideration the caseload of the European Court of Human Rights, which is increasing, the availability of domestic remedies is quite an important matter for the effectiveness and effective operation of the entire European human rights system. And that is why the European Court pays great attention to the proper implementation of Article 13. In its case law, the Court has elaborated upon the content and upon the concept, the very concept of remedy under Article 13, because, as you may remember from the first slide, Article 13 itself does not lay down any strict criteria or definition of a remedy. And the court, the European Court, has come to the understanding that the remedy under Article 13 shall mean an accessible remedy before a domestic authority, which is competent to deal with the merit of the complaint and to grant appropriate redress. So, as I mentioned, there are no strict written requirements for a remedy to be considered effective. Such criteria have been developed by the court in its case law over the years. And first of all, the court considers that the effectiveness of a remedy means that a remedy shall be effective in law and in practice as well. And that means, practically, that that the remedy should be accessible, capable of providing redress, and it should offer reasonable prospects of success. The last criterion, the last requirement means that that it is enough for a remedy to offer reasonable prospect of success. It doesn't need to guarantee the certainty of a favorable outcome for the applicant. As far as the type of form of remedy is concerned, the court has come to distinguish, or maybe the doctrine has come to distinguish right-specific remedies and general remedies. The first category refers to remedies which can provide redress to the violation of particular rights or particular types of violation of the European Convention. For example, in case of excessive length of proceedings, the preferred form of redress by the court is prevention. But alternatively, the court is also ready to accept as effective remedy compensation or a combination of preventive and compensatory remedy. And on the other hand, the general remedies, as the very term indicates, are of more general nature, and they can be used in cases irrespectively of the type of violation. A good example is a constitutional complaint. Let me now illustrate the court's approach to the effective remedy, to Article 13 and to the idea of effective remedies with some Central European examples, more specifically with the case law on Polish and Hungarian constitutional complaint, because I believe it will give us a nice possibility to somehow get a grasp of how the court understands effective remedies, taking into consideration that nominally the same institution, which is the constitutional complaint, has been regulated differently in both countries. So first of all, let's take a look at the Hungarian constitutional complaint, which is regulated in fundamental law of Hungary and in the Act on the Constitutional Court, both of which are in force from the 1st January 2012. Altogether, they provide for 3 types of constitutional complaint, the indirect, direct, and so-called real constitutional complaint. The first to allow for a constitutional review of legislation, which led to the violation of constitutionally guaranteed rights, either with a judicial decision or without a judicial decision. And the real constitutional complaint, the third one, allows an applicant to challenge the judicial decision itself and not the legislation. It's worth noticing that the third type of constitutional complaint, the real constitutional complaint, it was introduced to provide for more for a better protection of fundamental rights, and it entails the obligation of the Constitutional Court to quash successfully a challenged judicial decision. The constitutional complaint in Hungary, in its present form, has already been examined by the European Court of Human Rights, and it has been considered an accessible and effective remedy which offers reasonable prospects of success, mainly due to the obligation of the Constitutional Court to quash a successfully challenged judicial decision. Here you can see the two cases in which such conclusions were drawn by the court. It's the case Mádl versus Hungary from 2018 and Szalantai versus Hungary from 2019. Well, at the same time, it should be noted that the court has also expressed its opinion that there are some limitations to the Hungarian constitutional complaint. They are elaborated upon in the case Sándor Varga and others versus Hungary from its judgment of 2021. And I will elaborate upon it in the written part of my contribution. Before 2012, the Hungarian Constitutional Court, the Hungarian constitutional law, provided for two types of constitutional complaint, but neither of them granted the Constitutional Court the power to quash individual judicial decision, mainly because there was no possibility to challenge a judicial decision directly. It was not considered an effective remedy by the European bodies. Let's take a look at the opinion of the European Commission on Human Rights from 1993, in which the Commission stated that the then Constitutional Court was only entitled to control the constitutionality of laws in their generality and couldn't quash or modify specific measures taken against an individual by the state. So it has changed from 2012. Now let's take a quick look at the Polish constitutional complaint, which is regulated in the Polish Constitution of 2nd April 1997. As I said, it is regulated differently in Hungary. There is only one type of constitutional complaint in Poland, and it grants anyone whose constitutional rights and freedoms have been allegedly infringed the right to file a constitutional complaint for a review of legislation based on which a court or an organ of public administration issued a final decision on the applicant's freedoms or rights or obligations. So as you can see, in this Polish constitutional complaint allows for the constitutional review of legislation, and it's not against judicial decision. Nevertheless, after legislation, after the successfully challenged legislation, after the judgment of the Polish Constitutional Court, in which the legislation have been considered non-compliant with the Constitution, there is a possibility for the applicant to file a separate request for a reopening of a case or quashing of the judicial administrative decision in his case. So in other words, the Polish Constitutional Court, unlike its Hungarian counterpart, does not quash a decision issued based on unconstitutional legislation. Nevertheless, there is a possibility for an applicant to request so. So this is a two-step procedure, and there was a question whether such two-step procedure can be considered an effective remedy in light of the Article 13 and Article 35, paragraph 1 of the European Convention. And the European Court had the possibility to pronounce itself in that regard in the case Szot-Medyńska versus Poland. In its judgment from 2003, the court has held that the Polish constitutional complaint procedure provides for effective remedy, even though it does not provide for an immediate redress. But in this two-step procedure, the renewed examination of the case leads to the fact that the authorities will have to disregard the unconstitutional legislation. Here also the court has expressed its concerns about this two-step procedure, that it does have significant limitations. Here I put them on the slide, and you can read more about it in the written contribution. So to conclude, Article 13 of the European Convention, which establishes the right to an effective remedy, implies and requires primarily the practical effectiveness of national legislation. So it is not surprising that in its case law on Polish and Hungarian constitutional complaint, the court has been examining the practical outcome of the legal institution, either as one institution in three types, like in Hungary, or in case of Poland, where we have a two-step procedure. In both cases, the European Court has considered the constitutional complaint as effective remedy, but aside from legal implications, the court has also examined the practice of the state authorities, and in one of the cases the court has stated that it is ready to change his opinion on the effectiveness of the Hungarian constitutional complaint if the practice of states authorities starts to demonstrate otherwise. So thank you very much for your attention.